Hello, everybody, and welcome to History Bite number 88, dated October 21st, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Substantive Due Process. In the American legal system, we have two recognized forms of due process, procedural and substantive. We will give an overview of substantive due process. Black's Law Dictionary defines the concept of substantive due process as such. It is a doctrine that the due process clauses of the 5th and 14th Amendments to the U.S. Constitution require that legislation be fair and reasonable in content and to further a legitimate governmental objective when said legislation infringes upon certain fundamental rights and liberties. Now, that is in stark contrast to procedural due process, which exclusively focuses upon legal procedures when one is deprived of life, liberty, or property. Thus, substantive due process concerns itself not with procedure, but with the content of legislation per se. Substantive due process, like many things in the law, is both yin and yang. It is a mighty weapon that can be used by courts to protect individual rights and liberties against arbitrary intrusion and abridgment by state governments via the 14th Amendment, of course, and to the federal government by way of the 5th Amendment. But substantive due process can also be counterproductive, as it is a very subjective concept that effectively leaves judges in total control to decide what constitutes a fundamental right or liberty that is so special, so important, that virtually no amount of process will be sufficient in order to deprive you of it. Okay? Substantive due process, as I said, focuses on the content of legislation when evaluating whether or not it is so essential to ordered liberty. It is no new thing in American constitutional law, so let's not get it twisted. Many legal scholars argue that the first time American courts used substantive due process was by way of the U.S. Supreme Court's 1857 infamous Dred Scott decision, where from that decision, among many other terrible, terrible things, the court essentially recognized a fundamental, unabridgable right to take one's enslaved human property anywhere in the country you wanted without legislation interfering with your ability to do that. Okay? Part of the Dred Scott holding was that Congress could not prohibit slavery in the territories. A part of that holding that totally ran contrary to history, as slavery in the United States had always been an institution that had been very stringently regulated. All right. So where the court got that from, I don't know. And Congress had always possessed power to regulate slavery. That power comes from the Territories Clause in the Constitution, all right? They have the complete power had the power to regulate slavery in the territories. So the court reaching that conclusion, was obviously bogus and in complete contradiction with history, all right? But the court recognized that the essential fundamental right to carry your slaves wherever you wanted, was a component of substantive due process, all right? In the 19th century, with the case of Lochner versus New York in 1905, the court essentially established the principle of economic substantive due process, which enforced the belief that employer and employee have fundamental right to contract with each other without any infringement by the state governments, And of course, that was by the 14th Amendment, and that was later extended from the 5th Amendment against the federal government. All right. So the state governments and the federal government from a period of roughly 1905 to 1937 by way of substantive due process and their recognized right to freedom of contract, had seemingly absolute authority to contract with each other on whatever terms they wish. So state and federal laws which regulated working hours during the day, required safe workplaces, requiring minimum wages, much of that, if not all of it, would be ruled unconstitutional in some form. All right? That it violated the sacred and unabridgable right to freedom of contract protected by the 5th and 14th Amendments to the Constitution. All right. A totally made up right. All right. There's no textual basis or history to support such a conclusion, as the states have and have always had inherent police power to regulate businesses. All right. And the federal government certainly, has such power within its domain as well. All right. So that's again how substantive due process may not always work for you as an individual. Though, of course, now in the 21st century, and that's, of course, it started in the mid 20th century, the court essentially recognized a substantive due process right of privacy. Okay. Essentially with groundwork in the case of Griswold versus Connecticut, even though Justice Douglas didn't want to call it substantive due process. Personally, he hated the expression. That's exactly what the decision was, based upon substantive due process, all right? Though not expressly from the 14th Amendment or the 5th Amendment. He established it through emanations, all right, in that case from several other amendments in the Bill of Rights, where areas of penumbras of liberty, okay, guaranteed such privacy. Okay, substantive due process, all right, just taken from a different chest. It's essentially no different, all right? And the court has, of course, expanded privacy rights, substantially, including, reproductive freedom with Roe versus Wade, the right to an abortion, consenting adults having such freedom, of course, without governmental intrusion in many cases, right to marry. So we have Lawrence versus Texas and Oberfeld v. Hodges, So, of course, the court has expanded that. These are good examples of substantive due process. So in these later cases where substantive due process was used to invalidate state and federal laws that infringed upon essential freedoms, the court was expanding the general rights of the people, all right? Versus in the past when the court was protecting essentially the rights of businesses and the rights of slaveholders using substantive due process, okay? But all in all, in sum, substantive due process protects those fundamental rights and liberties that are deemed so essential to personal freedom that virtually no amount of, procedural restrictions to deprive you of them are acceptable. All right. And why this is a good thing, like I said, because certain groups certainly need this type of protection, all right, from majoritarian domination. But substantive due process, as explained, can also be dangerous because it allows judges to wander freely in the constitutional field as they please, declaring many things, which may have no traceable roots in the history of the document, okay, like a fundamental right to carry your slaves wherever you wanted, or a fundamental right between employer and employee, things that obviously have always had restrictions, declaring them to be fundamental rights, free from any regulation by the state. And folks, that's just simply not true. So it's essentially up to the judges, okay, to decide, invoking substantive due process, what rights are so essential and so ordered to human freedom, all right? So substantive due process can be dangerous. It can be very helpful. It can be very useful. It has been very helpful. It has been very useful, but it can also be turned against you. It's a double-edged sword, all right? Because it is such a subjective concept that places that mighty power in the hands of often life-tenured judges. And with that fact in mind, once those life-tenured judges, I'm of course assuming we're talking about the Supreme Court, once those life-tenured judges make such a decision, it's effectively final, all right? So you have to be careful, when shouting the praises of substantive due process, because obviously, just as much as it can be used as a mighty sword to champion your freedom, it can also be used as a mighty sword to take it away. All right? You may or may not agree with me, and that's fine. Let's talk about it. So if you have any questions, controversies, leave them down below, and I'll be happy to answer them. Thank you so much for listening to this History Bite. Take care, stay safe out there, and I'll talk to you at the next one. Peace.